Hello, everyone. It's Mr. Murphy. With the news about President Trump's COVID-19 diagnosis and questions about having an election in the midst of a pandemic, I've gotten many questions from folks about presidential succession and succession for candidates for the presidency. And again, not to sound macabre, these are valid constitutional questions and legal questions. So I hope to provide you a brief overview of what we do know and to let you know that there's a lot of things we don't know because much of this stuff is unprecedented. So let's start with probably what we know the most about, and that is simply what happens if something happens to a sitting president. There are protocols and procedures in place, and we can point to the 25th Amendment for that. Section 1 of the Constitution's 25th Amendment is straightforward, and we've seen it play out in our own history. It simply says, in the case of the removal of the president from office, his resignation, or his or her death, then the vice president becomes president. That's straightforward. And it's interesting because the original language of the Constitution was relatively vague on this. It was not clear whether the vice president actually became president or just assumed the duties of the presidency. So Section 1 clarified that language, declaring that the vice president does in fact become president in the case of removal from office, resignation, or death. Section 2 addresses vacancies in the office of the vice presidency, and it authorizes the president to appoint a new vice president that is then confirmed by Congress. In fact, this is what happened when President Nixon replaced Vice President Agnew with Gerald Ford. Section 3 of the 25th Amendment deals with voluntary transfer of power, and there is again precedent for this. So the President of the United States can transmit a letter to his cabinet and to Congress and assert that he is not able to carry out the duties of the office of the presidency, that he's incapacitated for a period of time. And the powers and duties transfer to the vice president, and they remain transferred until such a time as the president submits a new letter saying that he is, or he or she is fine to carry out the duties. And again, an example would be if the president has to go under general anesthesia or a similar type of procedure. You know, we saw this with President George W. Bush when he underwent some colonoscopy procedures and he temporarily transferred duties to Vice President Cheney. Section 4, we do not have a precedent for this part of the 25th Amendment. This deals with an involuntary transfer of power, where if a majority of the president's cabinet or a group that has been appointed by Congress declares that, in their opinion, the president is incapacitated or unable to carry out his or her duties and responsibilities, then the powers transfer to the vice president. Now, the president can protest that declaration, and it would ultimately have to be decided by a 2/3 vote in Congress. So again, no precedent for Section 4, but it is present there in the Constitution. Now, beyond the vice president, we do have something called the Presidential Succession Act. So the Constitution leaves it up to Congress to decide presidential succession beyond the vice presidency. If you've watched Designated Survivor, you're probably familiar with this. So immediately following the vice president, you have the Speaker of the House, Nancy Pelosi currently. You have the President pro tempore of the Senate, Chuck Grassley currently, and then you have the Secretary of State, Mike Pompeo, and then it goes from there in the order that the cabinet offices were created through the president's cabinet. But again, we've not gotten a point past the vice presidency in our nation's history. Now, things get much murkier when we talk about something happening to a candidate for president or a nominee. Okay, here's what we do know. We know that if a vacancy occurs in a nomination before an election, then most likely it's going to fall on the parties. Now, technically, a party could convene another national convention to choose new nominees. But given that we're less than a month out from the election, it would most likely be the party national committees that would fill any vacancies that occur among the nominees. So, we've never had a situation where either party has had a vacancy at the top of the ticket. But in 1912, Republican vice presidential candidate James Sherman died on October 30th, days before the election. The Republicans couldn't convene a national convention to nominate a replacement, but the president, William Howard Taft, ended up losing the election, so it was almost a moot point. Although the Republican National Committee did choose a replacement, Nicholas Murray Butler, who ended up getting all of Sherman's electoral votes when the Electoral College convened. So there is a little bit of precedent there. We're in a situation where most ballots in the states have already been printed. So there probably wouldn't be time to get a change of names on the ballots, which is where we get to the Electoral College. Because really, the Electoral College decides the presidency, right? So the people vote on November 3rd, 2020, and then the Electoral College convenes in December to cast the electoral votes. Now, each state really has the authority to decide how their electors are chosen and how their votes reflect the votes of their people. And some states, though, in fact, more than half the states have laws that bind the electors to a state's vote. And in fact, the Supreme Court just heard a case earlier this year that upheld the constitutionality of those laws. So the language of those laws is going to be quite interesting, because some states, like Michigan, for example, requires that electors vote for the ticket named on the ballot. So if there's a vacancy that occurs and the party fills that vacancy, but the vacancy is filled by someone whose name is not on the ballot, that raises significant questions about those laws. Other states simply require a partisan allegiance, right? So if a Democratic nominee wins the popular vote in that state, then the law requires that the electors go with the Democratic candidate, regardless of someone named on the ballot or not. Now, it gets murky if something happens after the election. The 20th Amendment says that in the case the president-elect becomes incapacitated, dies, resigns, then the vice president-elect becomes the president-elect. The question is, what constitutes a president-elect? Because the Electoral College votes on December 14th, 2020. And if a vacancy occurs between the date of the election and the date the Electoral College convenes, the question is, can the Electoral College just vote for someone else, right? And then that raises the issue that I just mentioned about the faithless elector laws. The other date to think about is that the newly elected Congress certifies the Electoral College votes on January 6th, 2021 at 1 p.m. So what happens if there's a vacancy in between that time? Does a candidate become president-elect on election day, November 3rd, 2020, when the Electoral College votes on December 14th, 2020, or when the results are certified by Congress on January 6th, 2021, right? So those are questions to which we do not know the answer. And again, inauguration is January 20th, 2021. So under the Constitution, the term of the president ends at noon on January 20th. So there's no precedent for not having a president-elect ready to go by noon on January 20th. We don't know what happens if that ends up being the case. At this point, all we can do is hope that these hypotheticals actually do not become things that we have to test in practice. But hopefully this clarifies some of the questions that you've had about presidential succession, vacancies in the office of president, and vacancies in candidates running for president.